I don't know if you know this, but AT&T recently revealed that 73 million customer records were released, both existing and former customers, on the dark web. If my information was compromised in an AT&T data breach, I'm not worried because Aura is always on, always doing the hard work to keep me safe. I value my privacy and I also value yours. You can go to aura.com/AV7 to start your free 2-week trial using this service. Also linked below in the description. Protect your information today, guys. It's super important, and I cannot tell you how much time it will save you in the event that you get into a jam. Let's get into today's video.
Hi, everybody. How are y'all doing? Welcome, welcome, welcome. What is today, Tuesday? Big day. Big day. The jury's going in to deliberate, and it's going to be fantastic. Let me know if you can hear me in the chat by kindly saying good morning. Let me know where you are coming in from. Shout out to all the people that are tuning in early, hitting the like button. Thank you for hitting the like button. You have done us a favor, done us a solid. Good morning to Valeria. And guess what, guys? They are already in the courtroom. So I have... okay, it says you're sounding better. Good. Yeah, I am. All right, perfect. LA's in the building. Look at Ohio's in the building. Butler, Pennsylvania is in the building. Okay, I got it. All right, everybody's here. Chicago's here. Tapping in from Chi-Town. Well, guess what, guys? I do have a set of slides that I wanted to evaluate, just looking at the closing arguments for Max Schardt and Doug Weinstein. So before the jury goes in to deliberate, we're going to see that. So it's 9:30 right now. They are in the courtroom, and what they're doing is a little bit of housekeeping. The jury is due in at 11, and then I have my evaluation that we'll go through as well. And then we're waiting on the verdict. What do y'all think? We're going to poll you guys in a second, but I don't want to miss a single beat from what is happening today. So let's jump right on into the trial and get started. And we are live, starting now.
Okay, we need to make sure we have taken care of all of our last minute housekeeping on the indictment, the verdict forms, the charges. Ms. Persfield shared an email yesterday evening that has what we think are the last things we need to take a look at. So if we want to just walk through those, I guess maybe the verdict forms are the easiest thing to look at first. And y'all just let me know if those look okay.
Okay. You're looking at the email that says final docs?
Yes, final docs, charges, etc. from about 6 yesterday evening. And it attaches each verdict form, the redacted indictment, which we definitely need to still address some things on, and then the jury charges may change based on what we do with the indictment. So let's just look at the verdict forms first. And hopefully those are actually in final form.
This is minor, Your Honor, but do we need an entire page for the
Well,
overt acts, or is that just a
Here's
good way
the
to break
thing
it?
is I thought about doing some lines, but then I didn't want y'all saying, well, if you put 10 lines, that
Not the
implies that they
lines.
should find lots of acts. So I thought if we have a blank page, it is literally a blank slate, and they can put nothing, 173, it'll be up to them. So that was my thinking.
Well, I certainly prefer that to the lines, so,
Okay.
but it's
All
very
right.
difficult to please us.
All right, then that's why it's there.
Well, Your Honor, as you know, the state would prefer the lines, but given that you've made it clear, you sort of made your mind up on this issue, I think that this is the most appropriate middle ground. The way it was before implied that there would be very few or any. And this is, as you said, it's a blank space.
Okay. All right. So Any other items? All right,
And I don't know if it's the same thing Mr. Schardt is standing up. On Mr. Stillwell's verdict form,
yep,
for count 49 and count 52, just for consistency, I would put the not guilty first and then the guilty.
I agree. Don't know how that one
Lady in
happened.
black today.
Ms. Percival, can you switch those around?
No Miss Love.
Thank
Glaring
you for
red
that
suits.
catch.
Your Honor, I'm going to object on count 2 and count 49.
Yes.
I don't think we should be putting the victims' names.
Why?
Well,
I mean, if you're going to object, you need to give me a reason.
because, I mean, I just never, I think it's clear what the 2 counts are. If we put a date on it, I wouldn't necessarily have a problem with it. I mean, I think it's clear that my client's charged with 2 murders. I don't think it's necessary to put the victims' names next to each count.
All right, well, I appreciate that objection. I overrule it. All right, anything else on Mr. Stillwell's verdict form? All right, hearing nothing, we will move on to Mr. Kendrick's verdict form. And it's possible that, I don't know if we have a guilty, not guilty reversal on that one, but if
No,
we do, we'll
it's correct on that one.
Okay.
Or consistent. Let's use that
Consistent,
word,
okay.
consistent, Your Honor.
All right, anybody have any issues then on that verdict form? I guess maybe you could, on the, I don't know why it's not showing up on mine. I don't have lines under this blank day of blank, but it looks like you do on yours, Ms. Percival, so as long as they're there. Okay, all right, so looks like at least the verdict forms are in their final form. The redacted indictment, and as y'all can see, and from the email, I determined that Overt Act number 175 shouldn't be in there because it seems to not assert one of the necessary elements to have made that a crime.
Yes, Your Honor. I understand the thinking behind it, but I don't think that's consistent with Georgia law. I think we've already established, and the court has recognized, an overt act doesn't have to be a crime, and therefore we would not have to have all the elements present.
You are asserting the crime of, did commit the felony offense of whatever, OCGA section whatever, so,
That was the first part, my Honor. Second.
okay.
Second part is this. Under Georgia law, and federal law is consistent as well, the state does not have to allege all of the elements of an overt act that does happen to be a crime because it is not separately charged. The pleading rules are not the same.
Remember, this is the RICO expert, guys.
Generally demur to an overt act. And so it's, while it might not be adequate as a freestanding charge, as an overt act telling the jury what we are saying was done, that would still be sufficient. They don't have to decide it's a crime. They just have to decide it's an act in furtherance of the conspiracy, because they're not separately convicting them.
I don't agree. If you have law that is on point, show it to me, but if you are asserting he committed the felony offense of possession of a firearm by a convicted felon, previously convicted of a felony involving the use or possession of a firearm, and you cite 1611-133, one of the essential elements of that is that he's possessing it while he's committing a crime. And y'all don't assert that.
I I understand, Your Honor. As far as it not meaning to be a crime, Yates versus United States, 354 U.S. 298.
That says if you assert it as a crime inside a statute, it still doesn't have to be a crime? I know an overt act doesn't have to be a crime. Are you saying that Yates is going to tell me that if you assert he committed X crime, you don't have to actually be asserting a crime, even though you're saying pursuant to XYZ statute?
So I was citing Yates for the initial principle.
That I understand.
Okay. I'm not representing to the court that Yates says all of the additional things you said. I don't have a cite off the top of my head, so I'll simply have to represent this to the court. But I will tell you that it is well-established federal case law, for example, that if a defendant is charged, let's say count 1 is conspiracy, and there is an alleged overt act, that overt act is also alleged as count 2. Independently.
Right.
The defendant could be acquitted of count 2 because the jury finds an element of that separate charge was not found, but it still functions as an overt act in furtherance of the conspiracy. Especially when, like the ones we're talking about here, there's more than one actor involved.
There's not here for 175, there's only Mr. Nichols.
Okay, all right. I still don't,
All right, again, if you find some law that is on point, you let me know.
all right.
By that reasoning,
I'm, if you find some law, we'll deal with it further. Otherwise, let's move
I
on.
agree, I'm with the court,
Okay.
but I'm wondering if that should also not apply to 174, 189, and 190.
So on those, I would like to know, let's see. Good question. All right, 174 and which others?
189, oh, sorry, go ahead.
189 and 190.
Friendly reminder to hit the like button on your way in. Thank you, guys.
I think those present the same situation. Yeah, I think you're correct.
And hold up, we got a poll up. Let us know how long you guys think it's going to take for the jury to deliberate. My money's on tomorrow, but let's see. Let's see. Judge's assistant at the bench. What we're doing right now, guys, is just housekeeping, making sure the verdict forms look good, all of that before the jury comes in at
So
11.
looking at, like, for instance, on Mr. Stillwell's March 17th, possession of a firearm allegation, It's also a substantive count 64, and it's saying that he did that on March 17th, and we know from the evidence that what everybody is talking about is the gun that was, I don't know if it was thrown out of the car, but the gun that was discarded during the chase. And, you know, I mean, I think we were looking at sort of the somewhat odd language of 1611-133.
Right. So I guess my stance, Your Honor, is that ultimately, when it comes down to it, the state did not indict this correctly, and the state did not put it in the overt acts correctly, and they specifically alleged a specific crime in the overt acts. So we moved for a directed verdict on the substantive charges, and Mr. Abate and the state provided case law that saved that and opened up the possibility for a lesser included, and I get that. But I don't see that same mechanism of saving the charge for overt acts.
Right.
And so that's kind of where we're at. Essentially, I'm suggesting that there should be a directed verdict on the overt acts.
Yeah, I mean, I think those overt acts need to be removed. 174, 175, 189, and 190.
Your Honor, may the state briefly address that issue?
Sure.
The state does believe that for the reasons that Mr. Floyd was just articulating about the case law for a substantive count of 133, as the court, as we have addressed, you can have the possession of firearm by convicted felon because it's a lesser included. Legally speaking, the argument for, an overt act language, which does not have to have as much specificity as a count that the jury is deliberating on. The first language in 190, for example, is possession of firearm by convicted felon. It obviously has the superfluous language because it's not completed of the underlying felony, but that same logic for a count, which has to be more perfected than overt acts do, because overt acts do not have to be crimes.
I understand they don't have to be crimes,
Yes,
but they've
Your
been alleged to be crimes with specific statute numbers. And yet y'all haven't included what would be essential to make them a crime. So are you arguing that the overt acts should be lesser included also, or what are you saying? What's your argument?
Your Honor, my argument is that if the jury is tasked to decide if on March 17, 2022, when Shannon Stillwell possessed the firearm by a convicted felon in furtherance
Previously convicted of a felony involving use or possession
What do you
of a
say in
firearm.
hands?
Yes, Your Honor.
What do you say in
That-
hands?
In the state's mind, the lesser included argument on a substantive count is a harder standard to meet than an overt act. There's no such thing as like a directed verdict on an overt act as there is with substantive counts. And so the state believes that that same legal principle of why a lesser included of possession of firearm by a convicted felon can be included on a substantive count is even stronger on an overt act.
So are you, so I'm
Yes, Your
clear,
Honor.
are you asking that these be converted into just possession of a firearm by a convicted felon in the overt acts? As
Essentially,
kind of a lesser included crime?
yes, Your Honor, and if the state, or if you, like, for example, if the state, from my understanding, were just to, redact, or essentially, yes, Your Honor.
All right.
And I'll let Mr. Floyd.
I mean, I think that there is evidence presented for that. It's, and I hope y'all understand what my thinking is on because 133 requires that it be asserted that they did this while they were attempting or committing a series of crimes listed or types of crimes listed in the statute, and that is in nowhere listed in your overt act. That seems to be problematic. But simple, if you will, possession of a firearm by a convicted felon, you don't have to be possessing it while committing a crime, you just have to be possessing it. And that has been asserted in each of these overt acts.
Well, and Your Honor, just to supplement what my colleague, Mr. Adkins, was saying, I'm holding this up because I've been informed they can't hear me behind otherwise. The point that this does different work as an overt act than it would as a separate substantive charge. Frankly, only just the fact that he had the gun during the course of the conspiracy is enough for it to be an overt act. And just he is in possession of a weapon.
I know,
The
y'all
rest of the
didn't
details.
allege it that way.
Well, that may be so, but it still does the work under it. I mean, it wouldn't.
They cannot return, I find overt act 190. He committed this crime when you have not asserted that every element of that crime. They can't possibly find that when it hasn't been correctly asserted. Y'all have left out an element. So unless you've got case law, you're not going to convince me on that one. Okay. We have moved on to whether it should be redacted, modified to essentially assert a Section 131 crime of simple possession of a firearm by a convicted felon. And I think that has been sufficiently asserted in each of these overt acts.
Excuse me, and the
Yes.
state may be able to find a case, but I haven't, and you may be aware of a case, Your Honor, and in my limited time, I haven't found one, but I don't believe that there's a case that permits the court to go back and
I do not have any idea whether there is.
Yeah, I do not believe that you can go back now and fix the error that they have made or whatever, fix what they have done at this point in time by modifying the allegation of this overt act. At this point, I just don't think you can do that. I think the only option is to redact it, Your Honor, and I think it would be error to go ahead and change that.
I don't know, so.
Because that's what we have been.
I'm sure we'll have some time between now and when we actually send it out for somebody to do some research on that. So we'll put a pin in overt acts 174, 175, 189, and 190. They're absolutely not going to be included as a 133 offense. Y'all can let me know if there is case law out there that answers our question on the floor right now of whether they could be converted into a 131 offense, since it at least asserts that, but I don't know whether we can change it like that. So we'll come back to that.
Just so I'm clear, do you want specific law subject and apart from what was provided last week that would allow?
Yeah, because we need it specific to, can an overt act, in the midst of a trial after the evidence has been closed, be modified to assert what would be a lesser included crime that is fully alleged in that overt act. All right. So our next issue
What's going on, Maurice? We got a wobbly camera.
let me jot myself a note down.
Yeah, the other thing is they're doing this at the 11th hour. Like the jury is due in.
All right, the overt
like
acts
60
that
minutes.
include Mr. Kendrick and others that I granted a directed verdict as to Mr. Kendrick that basically with regard to the possession of cocaine and possession of codeine. And that's easy enough to redact out of the substantive count of the indictment itself, although we need to actually look at, if y'all can open up the, what count is that, Ms. Pursfield? I'm sorry, the count. We'll do the substantive count first. I think it's highlighted. Okay. If y'all will look at count 57, the issue, I would just strike possession of codeine with intent to distribute and possession of cocaine out of the indictment. I know that it doesn't really matter with regard to Arnold and Williams. I mean, they're on this indictment, but they're not deliberating about them. So it really doesn't matter, I don't think, whether something that those people could be charged with is included or not, because all that the jury is deciding is Mr. Kendrick. So is everybody okay with us just redacting out possession of codeine with intent to distribute and possession of cocaine on the substantive count?
I'm okay with that, Your Honor.
Okay, all right. Now, the somewhat more complicated issue is when we go back to the overt acts, because that same thing is essentially included as an overt act as well, and those start around overt act 183.
And on that, if I may just briefly speak to that, Your Honor. I mean, we have a similar situation, I guess, that we're fighting with those others, and that the question is, do you redact the entire count, right?
And I think not, because with an overt act, it doesn't have to be that Mr. Kendrick was the one that the jury determines whether or not committed. The other people, they could think, well, Mr. Williams possessed that codeine, so.
But here's the problem with that. Let's say they come back in the jury verdict form and they list 183 as one of the overt acts that they find, right? We don't know if they found that because they found that Mr. Kendrick.
Agreed. So here's a possibility.
All right.
So I'm going to throw this out here and y'all can let me know what you think. If we have a 183 that alleges that the three people that are included, Arnold, Kendrick, and Williams, possessed marijuana with intent to distribute and a firearm during the commission of a felony, because those are still live with regard to Mr. Kendrick, and then maybe a 183A that says, or posits that Arnold and Williams possessed the codeine and the cocaine. And then we know, okay, it's 183. They think they all, or somebody at least, possess those two things. Or we think maybe Mr. Williams or maybe Mr. Arnold possessed the codeine or the cocaine, but we know it can't have been Mr. Kendrick because I've already determined that.
So just want to make sure I understand the court's suggestion. There'd be essentially I'm going to do a slightly different numbering system. There'd be a 183A, which has all three individuals listed, but you would remove the codeine and the cocaine. And then there would be a 183B, which would just be Arnold and Williams with the
codeine and the cocaine. Yes, that's what I'm proposing.
My only question with that is, are we facing the same situation, or with a question of can we then go and modify, I guess we can modify these overt acts. I don't know
mean,
if we
it
can
seems
modify.
like that's an easier question because it's based on me having directed a verdict that Mr. Kendrick can't have done those two things, so it inures to his benefit.
I'm willing to go with your suggestion as long as it's not taken by the court or anyone else, that I'm conceding that the ability to modify this overt act for A and B due to a directed verdict is a concession that you can modify those other overt acts that we referred to earlier.
Understood, and if we find out that you in no way can modify, then I guess our solution would be to just strike those two things entirely, but I don't think that is actually fair to the state when it could be that, you know, they asserted that all three of them did that, and it could be that the jury thinks one of them did that.
Yeah, and I'm not, while I probably should, I'm not disagreeing with the court on what you're saying with respect to that. The real key is going to be if we can find any law and what that law says.
Sure.
That'll be determinative
All right.
of some of
And
those issues.
you say I probably should, but you shouldn't if you, I mean,
Well, I mean-
I appreciate that you take your duty of candor seriously. I really do.
Thank
So
you.
thank you. Yes, sir.
Your Honor, with regard to Act 183,
Yeah.
if the jury unanimously finds that this overt act was in furtherance of the conspiracy,
Yeah.
I believe with the instructions the court will be giving, when you have multiple parties, you know, and could mean, you know, and can be or in pleadings. And so if the jury finds that this, which includes Mr. Arnold, Mr. Williams, and Mr. Kendrick, if they find it's an act in furtherance of the conspiracy, you know, it would be attributable against Kendrick and Stillwell. So I believe the state's current belief is that the way it is worded is safe with the instructions the court will be given about possession, constructive, actual, how you read and in indictments or pleadings, so that the jury, who's presumed to follow the court's instructions, will use those legal principles. And if they do find this overt act is in furtherance, it will be following that law.
Here's the
Yes, Your
challenge with that, and just kind of think through this hypothetical with me. We have got Overt Act 183 that says Arnold, Kendrick, and Williams. Let's assume that the only overt act the jury comes back with is 183. And all we know is they found 183. But how do we know then that they didn't say, you know what, I think Mr. Kendrick possessed codeine with intent to distribute. That is all I think, and that is why I'm finding this count. When I have already directed a verdict against the state and on the side of Mr. Kendrick with regard to that, that seems problematic. And then the whole case gets reversed, assuming that that's what happens.
Understood.
And
John.
I doubt if that's going to come to fruition, but legally speaking, that's my
Do the right
worry
thing,
with
Judge.
leaving it the way it is.
Understood, John. I'm thinking through it with the court
Yeah.
right now.
Okay.
So if we could come back to this.
All right.
Thank you, Your Honor.
I guess what doesn't make sense is we didn't have to charge the separate offenses. We could have just put those offenses like we did in the overt act, and your directed verdict on those obviously would have had no.
That's true.
Because there's no directed verdict.
That's true, but I'm worried about an inconsistent verdict, which is not allowed.
Well, inconsistent verdicts in Georgia are allowed. Georgia doesn't have inconsistent verdicts in what they don't go.
Well, what is it that we phrase it? It's not inconsistent. What is it called? Repugnant. And I don't know, this would be.
You see that,
this
Keita?
would qualify as
No
that, but
red.
It's factually, I don't know the answer.
Your Honor,
I just know the question.
I think we'll have time to return to this.
Okay.
I'd like to bring you, I'd like you to bring you some authority. But
Okay.
I can tell you that my understanding under analogous federal law is that there is not such a thing as an inconsistent verdict as between a substantive count on a charge and that being an overt act. The jury could find it to be the overt act, even though the substantive count they rejected explicitly. That's
Okay,
not
but that's not them, all right. If you can, I think that would be an inconsistent verdict, which wouldn't be problematic. Our situation is not that. Let's assume that nobody else is charged, that it's just Mr. Kendrick who it's alleged to have done overt act 183. And I have directed, and it's only, Cody, and I've directed a verdict on that count with regard to the substantive count. Could we then leave that overt act in? When I've said as a matter of law?
Actually, I believe the answer.
So that's our question.
Right.
Stumped.
Understood. It helps to frame the question.
Okay,
And we're gonna come back and talk about it, so I don't want to.
all right.
I'd like to be better.
Think it through
informed
before we
and
know what the case law
make
is.
better use of our time.
Okay,
Thank you.
appreciate it. All right, the next thing is on the overt acts that allege possession of a firearm by a convicted felon that aren't also substantive counts. We were adding definitions of, like, if, I don't know, Mr. Arnold was alleged to have committed an overt act of possession of a firearm by a convicted felon while he was convicted of, I don't know, dealing in some kind of drugs. And we would need to have defined what is that underlying crime in our overt acts definitions. But that would only be true, I think, if we then had, well, let's not have it be Mr. Arnold. I'm talking about Mr. Kendrick and Mr. Stillwell. They've been alleged to have been convicted felons based on convictions for gang act and burglary with regard to Mr. Stillwell, shoplifting and possession of dangerous drugs out of Arizona. As to Mr. Kendrick, I just want to make sure that those convictions are in evidence, and that ought to be easy enough to check. And honestly, I think, Ms. Hilton, you maybe even cited what the exhibit numbers were. I just want to make sure that is what those matched up to.
Yes, Your Honor.
So I think it was, what you said was 60G, 30Q, and 487VV. So can we just pull those and or if you've got it on this, you had it as a slide, actually. If you want to just pull that up too, and let's look.
And there are other convictions for Mr. Stillwell that were admitted as well.
Right, but I'm just, at this point, trying to figure out which crimes not otherwise defined do I need to define for purposes of overt acts. And we have not yet defined shoplifting, burglary, or whatever that Arizona dangerous drugs thing is, and I'm not even sure how to define that one, but looking at the indictment, plea, and sentence would help. And are we sure that was a felony shoplifting? Because shoplifting isn't always a felony. So can we just pull those convictions?
You want me to pull what I posted in the,
I mean, the actual
you want me to pull the
piece of evidence would be probably the easiest. Thanks.
Okay, so they've approached the bench, and yes, we're talking about shoplifting. So what they're doing, guys, they're getting everything ready for the jury in about 50 minutes, reading their instructions on what they need to accomplish today, or maybe tomorrow, or maybe next week. we're waiting, shout out to Miss Crotty Shetty. Gifted 5 AV memberships. Thank you. Miss Crotty, good to see you. Shout out to D with the 2. What? Fulton County not set tripping today? Yeah, they're not all wearing red. Shout out to D with another 2. Fulton County Gang Gang explains the whole case. Miss Crotty Shetty says, AV, you are looking so pretty, girl. Thanks for holding us down. Yeah, guys. Been covering this trial for 6 months. Never thought we would see the day the jury goes to deliberate. Shout out to our favorite Aussie Nene. Been a member for 2 months. Shout out to Shannon, who became a member. And we don't mean SB. We mean Shannon Soto. Shout out to one of my OGs, Julian Brown, the 10. Says, wow, sis, you've been doing your thing since I've been gone. I have. I'm trying. I got a lot of updates for you guys when we get to a break. But thank you, Jew. Very sweet. And then Jew also gifted you guys 5 memberships. I saw y'all say thank you. Shout out to Retro, who became a member. Welcome, Retro. I'm just doing some housekeeping stuff before the jury comes in, guys. Shout out to the Marie B with the 2. She says, good to see you. Good to see you too, sis.
Make sure you get it back.
Buddha Belly's in here. Buddha Belly been a member for 4 months. Says, so grateful for your coverage and inspiring soul. Aw, thank you so much. Yeah, this trial has been taxing. I can only imagine how the jury feels, everybody working this case. We heard a little bit of that from Angela. That was a good interview. Simone Hilton in a leather skirt, leather A-line. We stayed up late last night watching her final word. Oh my God. When you watch that on double speed, it is so aggressive. Shout out to Hanny. Hannibal the Conqueror. Been a member for 5 months. It's your 5-month anniversary. That's the green text gift. I love that. Thanks for your time with me. Yeah, what did y'all think of her closing yesterday? It was intense. All of them wearing red. Love's not at the table today. She was sitting there like a proud mama. Every time Simone raised her voice and the hood came out. Okay, you guys say aggressive and rude, very aggressive. Too loud and too long. All right, let me see if I could skip some of this. Are we out of TiVo time? Yeah, we're all out of TiVo time. We're just waiting for the judge and her assistant to finish talking about something. And then the jury is in about 45 minutes. Y'all are like, rude. She was rude. You know what? The ladies thought it was very unprofessional.
Yes, Your Honor. You were talking, that's why, I'm sorry, I waited.
We were just dealing with other issues.
Tamara, I was thinking the same thing. Or Tamra. Let me know how you prefer to pronounce your name. Yeah, Woody did make
Your
her
Honor,
cry.
unless I missed it, I don't believe the Arizona conviction came into evidence.
If 438 VV, now you had cited in your closing presentation 487 VV.
It was 438 BB, which is this
Okay,
for,
all right. So it doesn't look like the Arizona conviction came in, so.
Hold on, who got the tea that she was crying yesterday? Where's it at? Let's dig that up.
All right, so we're starting with overt act number 3. Y'all allege that Mr. Stillwell possessed marijuana with intent to distribute on 8/23/13. Is there a conviction for that? In which one is that?
that is going to be, yes. Well, no.
It's neither of these. Aren't there 3 for Mr. Stillwell?
Yes, Your Honor.
All right, you handed me 2.
I handed you the 2 that we discussed.
Okay, can you hand me all of the convictions for each of them that are in evidence? I just assumed that you had cited all of them in your closing, but that's okay. It's probably this one. No, this is a 10 SC. It can't be that one. It can't be that one either. All right, I think it's still somewhere in one of those bins, if it is in evidence. All right, Ms. Persfield, the burglary one, there is a conviction for, so we do need to define burglary in our overt acts.
Your Honor, for the 2013 Act 3, we put up evidence of that. I'm trying to see
2013 Act.
Act 3.
Okay,
Sergeant E. testified.
okay, all right, as long as there's, okay, so there's some evidence, okay.
Yes, Your Honor.
All right. Just a second, sorry. All right, and we've already defined possession of marijuana and the intent to distribute anyway. Yes,
I don't think it's necessary to define the, I guess, the burglary for the example that you just referenced as it relates to that conviction. They just need to determine that what they have is a felony conviction and that they've been convicted of that felony. There's no added, I think we're just adding extra charges
Okay.
and confusion to the jury to have.
I see what you mean. That's a good point. If there's a conviction in there, then they don't need to make a determination whether that occurred. It's proven by the conviction. All right, that's reasonable. All right, so then 55.
Blessed and anointed. The same SB that's married.
So are there other overt acts that have been proven by somebody else's conviction being admitted, such that we wouldn't have to define those either?
So they did stump the RICO expert, who is the bald man on the left, and the judge asked him a question, and they needed evidence and case law to support it. That's why it's a little slow right now. Jury due back in
Right,
about
y'all,
30
Overt
minutes.
Act 58 alleges possession of a firearm by a convicted felon by Mr. Kendrick by possessing a firearm having been convicted of that Arizona felony. Is that conviction of possession of a firearm in evidence?
No.
Not the Arizona conviction, but I don't know if it's I assume Georgia conviction for possession of a firearm by a convicted felon?
That's the one that you have, 438 BB.
Okay.
That October 1st, the conviction for that October 1st crime is 438 BB.
Papa Doe, y'all so funny. Yeah, that's why I wasn't live yesterday, guys. My flight got delayed to Atlanta, but I'm here now. I am here for the holidays.
All right. All right, so you can put it back where it goes. And then have y'all come up with any other overt acts where we won't need to define a crime because it's established by some alleged co-conspirator's conviction that's in evidence?
Your Honor,
Oh.
we are looking, Your Honor, we're looking at that now, and I think the court just addressed this, but just with the Arizona conviction,
Yeah, we don't need that one. We just need the, yeah, that one's satisfied.
thank you, Your
Thanks.
Honor.
Yeah, Hilton came in with her pleather today after that red. Straight dominatrix. Shout out to Ramon. Yeah, I heard about this case. Does anybody know when the trial date is? I know they're meeting on Karen Reed today. Thank you, Ramon. I'll look into it. That's actually going to be a big one. Something going on at this prosecution table.
Sorry, Overt Act 34 is Walter Murphy, possession of firearm. Do we have, is that established by a conviction? Or am I going to need to define robbery?
It's established by conviction, so you would need to define robbery.
Okay, that may have been the only reason we were defining robbery, so we would not need to if there's a conviction in for him. So we can take that out of our jury charge. I'm glad you pointed that out, Mr. Abadi. That'll make it somewhat easier.
Mr. Schardt was instrumental.
Mm-hmm. Oh. All right, I'll have to look in a second. Okay, it doesn't look like there are any other overt acts, because I just did a global search in the indictment for the term convicted felon, and that looks like those were all of them that didn't otherwise have some definition anyway.
I can't believe they're scrambling and scraping 28 minutes before this jury is due in to start their deliberations. Why does it not surprise us? Where are y'all on the poll? How long does it take for the jury to deliberate? That poll is up. 36% of you say tomorrow. 32% of you say today, end of day today. %16 of you say it's a half day, another tie, 16% next week. Thursday's holiday is going to prevent them from continuing, so it's either today, tomorrow, or next week. Yeah, guys, we're waiting for the jury to come in, about 25 minutes. They're getting their stuff together, all these documents and things that need to go in front of them, jury instructions, double checking the overt acts. I have some stuff to look at for us at 11 if they're still not ready.
What's the name of the case you found that said you could change the count from 133 to 131?
Well, Martinez is one of them.
Martinez, do you remember the site for that?
I can get it to you.
Thank you.
All right, y'all on board. Okay, let's do this. I'm gonna remove this for a second. We're gonna share this instead, and we'll come back to it. Real quick, as we're waiting for the prosecutors, what I did yesterday is I took some time to really take a look at the main points that the jury is going to have to think about when it comes to the defense closing arguments. Last night, I was able to pop on here late because of this delayed flight, and we briefly talked a little bit about Simone Hilton's closing argument. And, Atkins took a lot of time that morning to talk about some basic concepts, things of the like. We've heard a lot from there, but it was rather unentertaining. So I took a look at both closing arguments and broke down some really important things for y'all to look at. And it's really going to start with what the defense attorneys were focusing on. Okay. So let's start with Max Schardt. And we have the defense of Shannon Stillwell. Now, what did Max say? He said that Shannon is not guilty on all counts. Okay, so let's break that down as he was going. One of the first things that he mentioned was that expert witnesses. You guys remember Detective Viverito? Analyzing the credibility of the 5 gang expert witnesses. And he called it an echo chamber with one voice, even though it should have been a single witness. That's the thing. If you're going to continue to have the same people over and over talk about the same stuff, over and over, did you need all of those witnesses? So this was one of the first key points that Max made and is really important for the jury to think about as they deliberate. Next, he talked about the Super Slimy album. You guys remember that? That was the album cover with the snake on it. And that Super Slimy album cover was a call, at least that's what the state is painting it as. It is an alleged call to war against Bird Gang and not simply Future's Eagle logo. Weird, because you would think, as the state puts this together, you're going to have concrete evidence that's going to tie these people to these crimes and go from there. That's not what we saw. It's not what we saw the state prove, but they're alleging it, right? So the Super Slimy album cover came up. Next, personal stakes. We come back to Detective Viverito because, super polite on the stand. Now, one thing I picked up on when it comes from Max's delivery is we had this alleged marriage between Caleb Bumpus and Shannon Stillwell, right? A lot of people didn't know about it. It allegedly took place in August, and we found out about it 2 weeks ago. So interesting. And then we had some moments where Viverito and Kayla were going back and forth. There were terms like hoe being thrown around and a bunch of shenanigans. So it's like, okay, now this is personal. So you have a defendant who is married to one of the attorneys that has been involved in the case, and then you have this detective who was allegedly involved with him as well and is going back and forth in some personal capacity. Max, at some point, needed to address that. Now, she did make a misrepresentation while she was on the stand, and she was talking about Young Thug in particular. And it was a quote, and that quote was, putting 24s on a ninja's head. Putting 24 M's on a ninja's head. Now, when Max asked her about this, Viverito unexpectedly said she'd do it again, right? And huge shout out to Thugger Daily. That team had done an excellent job yesterday, and that's how I was following the case as I was traveling. They were breaking everything down minute by minute, and every time a key point came out. So a lot of this is kind of starting with some of the points that they were doing it in real time. But this was important because they were pulling it back to when we saw those things, all right? So we have all of those things. Now, as you were talking about credibility of expert witnesses, we talk about this all the time on this channel. When you have an expert witness, not only do you have to qualify that expert witness, they need to have knowledge, background, experience, and training in the topic in which they're testifying to. Now, if we look at Viverito, for example, her training was the Georgia Gang Investigators Association, GGIA, right? The other thing is the manner in which you testify, interest or lack of interest in the case, and personal credibility as you deserve it. There were some things where she made comments about her opinions of things, but not necessarily in the opinion or the lens of an expert witness. So he had to really take some time to address the personal stakes and why it's important to his client in particular. And he wants to make sure that the jurors see this when it's time to evaluating her credibility, right? Super, super important for that one. Let's keep going. Next, what is the benefit of YSL? All of these gentlemen, in some shape or form, the benefit being involved with Young Thug and YSL was that it was something that benefited their career. And the aspect of SB was, an artist. These last two defendants that we have in this particular proceeding, both had music careers connected to YSL, connected to Young Thug himself. So they immensely benefited their careers by associating with Young Thug. Now we heard things about Moontunk, like Moontunk, I think, was in charge of security. At some point, Little D was in charge of merch. Thug was trying to get these guys off of the street, and we heard conversations like this, even down to Woody, where, you hear people around Thug. I think Thug's sister would say to Woody, why do you keep going to Mechanicsville? Why do you keep going there? We keep telling you to stop. Shenanigans, right? So there's a benefit, and Max focused on that a little bit. Next, gangs. Do they equal YSL? Is YSL a gang? Max contrasted what we know about gangs and what we've seen about YSL. And the question then becomes, is it a gang? Now, Ms. Hilton in red screamed at the jury last night, and she screamed that YSL is a gang. That these acts, all of these crimes, remember the puzzle pieces, they were connecting. They all connected back to YSL. Why does she have to do that? Count 1, RICO. That's why she has to do that. They all have been charged with count 1. Even the people that have taken plea deals, count 1 was on nearly all of those plea deals. Now, when he talks about if being in YSL and being in a gang are the same thing, he's saying that those are two separate things and that they're inconsistent. However, Max did say that a lot of these people committed these crimes, but did they do it in furtherance of a conspiracy? The reason why the language in furtherance of a conspiracy is, like I said, it's connected to count 1. So these jurors have to go in and they have to look at that. Like, are we really going to say that all of these individual crimes benefited YSL, were in furtherance of YSL, and things of the like? Let's keep going. Now, here's where the plot thickens. And, I know you read this on the screen. You're like, AV, come on, pause. Nut in songs. There were references because the state then bought up the murder of Donovan Thomas. Peanut, right? They referenced this murder a ton of times throughout this trial, and it was really the nucleus of their theory on the case. Now, Max did something brilliant here. He said that SB leaned into the street life to promote his music, but he reminded the jury of something. So although they're using references as lyrics as evidence, they reference songs that Shannon had put together. Now, what a lot of people forget about, and this was good that Max brought it up, was, do y'all remember that music video that Little Woody has? You can watch it right now. It's violent as hell. It's still on YouTube. It was posted about 4 years ago, and they played it during this trial. Most of y'all were here for that. You remember that. Now, one of the scenes in the video shows a man that looks just like Nut. Big, heavy-set guy, dark skin. I think he was wearing a wife beater. And they had a bag over his head. And Little Woody and others, I think Tay was there too, in the video, rapping about the song. Now, That is a visual depiction of this crime. Is it subjective because music is art? Everybody has a right to the First Amendment, freedom of expression, all of those things, right? All of those things are happening. Now, that's a reference, two different references to Nuts murder in a song. One is audible, where you can hear it. Did SB make a music video the way that Little Woody did? No. But guess what? And I loved this. Max mentioned, and this is the very last line on this screen, Little Woody depicts an individual that looked like Nut being violently deleted, yet Woody was not indicted. Woody was not indicted. Woody was not, I repeat, indicted. So, interesting point, and I hope that really landed with the jury. It landed with me, but again, I have legal brain, right? So when we talk about the references to Nut in songs, this is clearly important. Now, another big point that Max brought up, Woody and Little D. Max talked about the consistent lies that Little D stated. And I know this because we have put together a lot of compilations of some of the best performances from these attorneys. We did the best of Brian Steele, which you guys wanted to see. And then we did the best of Max Schardt. And one of the most brilliant moments in this entire trial was when Max Schardt had Little Woody on the stand. And it was revealed to all of us, because this is a huge, huge failure on the state, that when Little Woody talks about telling the truth and telling the lies and mixing them together, he mixes it. He sprinkles a little bit of that, sprinkles a little bit of this, and he mixes it. Why did he do that? Because he wanted to go home and get out of jail. Now, the detectives clearly knew that Little Woody had been doing this for years. They know it. They've said it to him in some of the pieces of interrogation footage that we saw. This ain't no 68. You gotta do something for us too. So these detectives had knowledge that some of the things that he said was not true. And the nerve of Simone Hilton to say that detectives were going out and verifying the things that he said. Yet, did you verify back in 2015 that Little Mike and Quez were not real human beings? That they were fabricated, made up characters in a fictional story? And one of the biggest wins for Max Schardt was getting Little Woody to admit that on the stand in front of this jury. So it's a huge win to keep in your back pocket, and I was expecting to see it in this closing argument, and it did show up. So I'm glad that he brought that up. Now, that shows that he is not a credible witness. State, these are your witnesses. And although they are your witnesses, they are turning on you. And so we've watched that for a few months. And Simone Hilton last night was just like, oh, they're turning on us because they're friends and they're trying to show that they're still loyal to their friends. And again, I'm saying it in using a normal tone to explain that. Okay. But they turned on you. You guys selected them. You picked up paperwork. You set up plea deals. You gave these men pins to sign them. The other really big point that Max made, because remember, his interest is SB's interest. His interest is Shannon's interest. Whatever is in the best interest of Shannon for him to not get convicted of these crimes, because the state has the burden, and we'll talk about that in Doug's part. But Little D's stories have changed so many times. Why? Because at the time, he was facing 185 years. Not even that. He came up on the stand. They dragged him out of hospital bed. He had IVs hanging out of his arms and was legit high on the stand. Perks. Oxy. The doctor said before he came on the stand that it was perfectly fine for him to testify. Do you understand how much of a mockery this trial has been for Georgia taxpayers? and then to scream at the jury and say that they did that because they still want to be friends with the individuals that were sitting on the other side of the room behind defense attorney tables. Good point from Max. He continued to cook. Missing evidence. Do you guys remember Brian Steele asking every single witness from law enforcement, particularly Detective Thorpe, where the McDonald's footage was? This McDonald's footage that captured all of these men congregating to discuss this murder, congregating, your cell phone evidence, all of it. One of the most important pieces of evidence was not made available at this trial. And when asked about it, oh yeah, I went to the McDonald's and apparently a week goes by and then because of their records retention policy, they record over the footage. It is McDonald's. But one of the most important pieces of evidence that would place all of these men at the scene of the crime is missing. And then, how do you know that you went to the McDonald's, Detective Thorpe? Oh, because I wrote it in my notes. All right, is that notebook made available? No. It was destroyed. There you go, Georgia taxpayers. My money went there. I just paid my taxes, but that's where the money went. The footage from the McDonald's miraculously was unrecovered, indicating a sloppy investigation. Saying it again, indicating a sloppy investigation. And emphasis one more time for the cheap seats in the back. Indicating a sloppy investigation. And Miss Hilton stood in front of that jury and screamed at them and said that these detectives were going out and verifying information. Let's keep going. Next, Woody did these crimes. Very important because I think for Max in his journey, he in particular had been uncovering a lot with little Woody on his stand, uncovering some of the lies and getting little Woody to admit it. Rich Homie Quan's Daddy's Barbershop, all of that. Now, what Max, because he was able to get little Woody to admit to some of these things publicly, he presented the case as if Woody and Threat were behind Donovan Thomas's murder, not his client, right? So you had that one come up. All right, Shamel Drinks. We know what happened to Shamel Drinks was a horrible tragedy. Not okay. Nobody wants to pass away at a stoplight, due to gang violence and due to gun violence, right? Now, Schardt's angle on this was playing the wiretap of what was thought to be a private conversation. Because remember, they have this as a piece of evidence. It is, some of these phone calls, these jail phone calls. And, some of these brothers did talk a little bit too freely with some things. But the angle that Schardt is going for is that, of course, he's going to talk freely about something because if he committed the crime, why would he freely talk about it? So it was a private conversation in which Shannon says that they are just assuming that Shannon had something to do with the murder because he was at the gas station even though they didn't do anything, and it'll work itself out. Some of this language is subjective. The gas station footage, yes, the car leaves and the two white cars go behind it. But direct evidence is what is required here. Direct. Let's keep going. Now, let's look at the pieces of evidence that came up through Max. The medical examiner had some testimony, right? And this is all recent because it's still fresh on the jurors' minds. And the medical examiner said that the victim would have instantly lost all movement. Because you guys remember when Shamel was shot, apparently his foot was lodged on the brake or something along those lines. It was the position in which his body took its last breath, right? So that came up and was a huge topic of discussion. Now, the flashing of his brake lights while Shannon's car was there would have been impossible. The other thing you heard about a lot was a muzzle flash in the FedEx surveillance footage, right? That came up through Detective Viverito's testimony. And Max asked her, do you see a muzzle flash? Because I don't see a muzzle flash. We haven't seen Rico. We've been looking for Rico. Maybe the muzzle flash is with Rico. Where is it? And then most importantly, and you guys picked up on this, many of you had sent so many creators, so many legal people, some of these attorneys themselves, you have been looking at that surveillance footage, finding some issues with it. There was a random person walking, all of those things. Issues with this surveillance footage. And there was a third car in that surveillance footage. And it arrives after Shannon had already left. And they placed this car as a person who was the actual shooter. The last brake light flicker of Drink's car was 34 seconds after Shannon had already left. So we have all of that. That is your conclusion of these. And again, guys, these are my notes of just analyzing what was said in front of this jury, what the jury needs to think about. And this was in retrospect after watching Simone Hilton last night. And it's almost 11 o'clock, guys. I am going to go back to the trial to see what's going on, because they should be coming back. The jury is due in at 11 for final jury instructions, and then we are going to watch them deliberate and see if they come back with a decision today. All right, this is short and sweet. Doug Weinstein came up, and this is the defense of Diamante Kendrick. Not guilty on all counts. Key points here, not many, but we're almost done. I just want to quickly take you guys through this. Collateral damage. I love this, that Doug said this. Collateral damage. Doug acknowledged that Yak Gotti made mistakes in the past, but since then he has done nothing but focus on his music. The state didn't let him do so and sucked him into this case. So that's a big theory. He wanted the jury to remember that. In addition, he wanted the jury to remember that these people were wearing red. I showed you guys last night when we looked at the closing arguments that their slides included little glimpses of red. When they were talking about their timeline, some of those boxes lit up red. If you're really a PowerPoint genius, you know how to make that happen. They looked at the timeline, and when it came to certain words, they would highlight the words in red. This prosecution team tried to use color theory to get these people to remember these key points in red, right? And Doug Weinstein pointed out that they were wearing red. Going to continue. Reasonable doubt. And I pulled some of this for you guys too, just so you know what reasonable doubt means. And that's at the bottom. But the other big thing that they mention is one of the biggest examples is such as the minutes before the Thomas murder, Donovan Thomas murder, Yak Gotti is on video entering a completely different car. Yet there has been zero evidence putting Yak in the Infiniti. That is why this closing argument was short. He's not even in the damn car. We sat here for 167 days. Those jury members sat here for 167 days. Y'all don't even want me to get started. I have a definition on the bottom for reasonable doubt. This is pulled from Black's Law Dictionary. You guys know I love that thing. Reasonable doubt refers to a lack of proof that prevents the judge or jury from convicting a defendant of a crime. You kind of have that here with Yak. The prosecuting attorney must provide proof beyond a reasonable doubt to establish guilt. That means there is no doubt in your mind, court of public opinion, that this person did this crime. So I'm going to ask you guys right now, Justin Diamante Kendrick, put a 1 in the chat if you think that there is proof beyond a reasonable doubt that he did this crime. Put a 2 in the chat if there's reasonable doubt that you're like, yeah, I mean, maybe there's some doubt here. And that's a big thing that you see. So let's keep going. I'm seeing all two so far. I liked this point too. Follow the money. The reason the state showed 0 financial records from Young Thug is because it would show all his earnings were legal. And it would work against them trying to seize millions of dollars of his cars, jewelry, and money. I'm telling you guys to follow the money. Because with RICO, organized crime is really centered on following the money. You know what that closing argument last night included? Not following the money. Can a jury convict these men today, giving these circumstances? Lastly, last one, and then we're going to go to we'll go to the courtroom. The burden of proof. And this is me telling you guys this. This came from Blacks as well. The burden of proof describes the standard that a party seeking to prove a fact in court must satisfy to have a fact legally established. Let me put that in English for y'all. You say, hey, AV stole my car last night. Okay, prove it. Because you're saying that I did that, you need to prove it. Go tell it to a jury. We got video of AV like breaking in. You know, like picture a little 1994 Honda. You guys remember the arms back in the day? What do they call them things? The big red joints. You put it on so nobody steals your car. You guys, if you grew up in the 90s or, you know, were around in the 90s, then you remember that. Some of y'all too young. But the red arm. If you got pictures, Polaroid pictures of me being caught red-handed with that in my hand, and it appears like I'm running away with a ski mask and all of that on, then maybe I stole your car. I took the joint off, I threw it outside, I got in the car, I hot-wired it, and I went. The club. That's what it's called. I'm like, why are they typing the club? Are we going to the club? No, the club. If you have proof that I hot-wired your joint and stole your car, then yes. But guess what? You have the burden of proving that. So the state, they operate on behalf of the victims. You have to help prove the crimes. That means with the state, with the district attorney's office, they have to work collectively with law enforcement and investigators to prove that these crimes took place, to actually get justice for these victims. People were saying that Shamel drinks his family. His mother was in there yesterday crying with Simone Hilton. I haven't seen that, but if that's the case, why? Because she wants justice for the murder of her son. But this investigation was caught sloppily or done sloppily. Let's get the right person that committed this crime. Also, if it's about that, don't tie it together. Don't mash it together with RICO. Don't piece it together in puzzle pieces with RICO. Do the right thing and get these people justice. So some people have thoughts like, oh, you know, a lot of these YouTube channels, you're pro-defendants, you're pro-defendants. Well, yeah, we're pro-defendants, but also in the aspect of justice, get the right assailants and try them the right way, the right trial mechanisms, not a big conspiracy. Crimes were committed. Process them one at a time. There's a reason that the previous DA did not bring this forward. And I've got some other tea. There might be a press conference later today about some of the things happening in Fulton County. There might be a press conference at 2 o'clock. We'll talk about that later. But interesting. Anywho, I really took some time yesterday. I felt bad that I wasn't here yesterday. And I wanted to take some time to really piece that together and explain it to you as if you guys, court of public opinion, if you were sitting in that jury box today. What are you going to do? Is there enough? Visuals are always important. Let's come back to the courtroom. We've got a little bit of TiVo time. I'm going to skip through some of the fluff. But as you can see, you can look at the clock on the back of the screen. And this is 20 minutes before the jury is set to arrive. And look at what they're still doing. They are still scrambling and scraping to get their documents together. Oh, I wish I had my soundboard right now. You guys are saying not guilty would be your verdict. You guys know how I am when I get passionate about things. I had to go in right there. Let me see if we can skip through a lot of this. And then they went on a short break. Are they still on a break? They are still on a break. So it looks like they're still putting that material together. As usual, they're still on a break. Let me refresh the page just to make sure. Yeah, they are still on a break. So it's 11:08. They're supposed to be in at 11. Hopefully a juror's not late, but super, super interesting. Shout out to Michelle who gifted a membership. Thank you so much, Michelle. Really appreciate you. And while we wait, guys, I do want to look at some highlights from yesterday as well. We do have some footage of some really good moments, so we could do that to pass time. Let's share this. This is one of the key moments from Max's closing yesterday. It's a 2-minute clip, but let's look at it.
It's Stevens in that Cleveland Avenue neighborhood. You're struggling, you're dealing with the same things that Jeffrey Williams is. And you're ashamed and you don't feel good about yourself. But then all of a sudden you see someone with confidence. Someone that's not ashamed. And all of a sudden, you know what else? They can rap. And people are starting to pay attention. And the shows start being booked. And 1 second it's around the corner, next second it's up the street, and then all of a sudden it's downtown Atlanta. Think about the pride. If you have nothing and you see someone that you know making it, and making it on his terms with that level of confidence. Now think about if you're Shannon Stillwell, raised by your grandmother, facing many of the same issues that Jeffrey's talking about, that he's rapping about, that these young men in Cleveland Avenue are facing. Many of the same challenges. And then you also want to be a rapper. And all of a sudden, this person that you can identify with, this person that has the confidence you wish you had, this person that's taking everything negative and turning it into a positive. And then he raps too. And it's all blowing up in your backyard. And you want to be a musician. And you want to go into the studio. And you want studio time. And you know Jeffrey Williams and his friends have studio time. Because now they have backing. And studio time ain't cheap. And you want connections. And you know he has connections. And you know those connections have paid off. B Slime, we know he's been on songs with B Slime. Vito, a songwriter for 300 Entertainment. Dolly, Rooney Lee, a signed artist. Shannon's been on songs with him. If you're Shannon Stillwell, isn't that exactly where you'd want to be? Isn't that exactly who you'd want to associate with? Not to conspire to violate any RICO laws. You want to be there because he's doing what you want to do and you are identifying with him.
Interesting. So again, guys, I've been scouring this just the Twitter feed yesterday to like really look at what people were saying, what some of the highlights were, and it is interesting to see what Max's key points were, and I've compiled them for you because I'm like, all right, what's going on here? Are we in the courtroom live? Just refreshing. So we're not back in the courtroom live just yet. Want to show you a few more other moments that were important for Max's piece. I want to go to the Woody one. Yes, this one was huge right here. Let's look at this.
Mr. Stillwell is just a kid who was raised by his grandmother in Thomasville. Nothing more, nothing less. But all of a sudden, he was known as a tough guy behind this. Wasn't true, but that was the public perception. That was the persona that was thrust on him. And maybe, while he was sick of it, sick of being shot at, sick of being chastised, sick of being threatened, maybe also a calculation was made. You know what? If they're going to keep shooting at me, I might as well lean into this a little bit. That does have traction in the streets. That does have traction in the music industry. Maybe that's why he's hashtagging his rap name in the post. The bottom line is, yes, I acknowledge he's referencing Donovan Thomas in songs. He's not giving any inside information in these songs that wasn't publicly known. Remember, he had been arrested. He'd been at prelims. He knows what the case is about. He's heard testimony about the case by this time, by the time he's making his songs. So he's not sharing any information that only the killer would know. Of course he's not, because he's not the killer. But maybe he is leaning into the bad boy image a little bit. But here's the thing. You might like my explanation or not. But could you put on 27, please? So let's just think. If songs were confessions, what would that really mean? Could you put on 28? Remember that song, Homicide, by Lil Woody, Kenneth Copeland? Who played the role of the assassin? Threat, Trevante Turner.
That was a brilliant move. That was a brilliant move. I mean, if songs were confessions, I do like that slide. Real quick, guys, it looks like they're back in the courtroom, seeing some movement in there, but I just want to capture a bit of super chats. Shout out to Mama D, who gave out 5 AV memberships. Mama D, thank you so much. Very, very sweet of you. Really appreciate you growing the community along with most of us here. Thank you so much, Mama D. And if you guys received a membership from Mama D, please say thank you to her. Very, very sweet. Did not have to do that. But thank you so much, Mama D. Shout out to John Robert with the 20. John says, I would be the juror that walked in the back and said they're not guilty. You're not changing my mind. So if it's 2 options, we all say not guilty, or we turn around and walk back out and we say hung jury. Well, John, this is a good point, because this is the thing. When you're on a jury, you have to talk these things out with a group of other people. These are other minds. People could be stubborn. They might see a point that you see differently. So that's what they have to do today, is deliberate. They have to talk about all the evidence, talk about 167 days worth of testimony. So interesting. But thank you so much, John Robert. Shout out to Break of Dawn, who gifted 10 AV memberships. Thank you so much, sis. I really appreciate the 10 memberships over here as we're growing this little channel that could. Thank you so much, Break of Dawn. Really appreciate you. You know, guys, we are on the path to 100,000. I'll tell you more about the goals that we have for 2025, but me and this team are so focused. We want to make it so bad. And I'm so thankful that all of you guys are here, you're subscribing, you're watching the content. Even when I'm not streaming, you're watching our shorter videos, right? And we're trying to do our best to improve, to enhance, to be the best that we can be, to bring you guys information about injustice and explain it to you in layman's terms, right? That's what this channel's promise is, and that's what we do. So Break of Dawn, thank you so much for gifting those memberships and growing our community. If you received a membership from Break of Dawn, do the right thing. Say thank you. Shout out to DB with the 2, says AP, Appreciate you, AV. Gotcha. Thank you so much. Sometimes I try to catch y'all's typos. That was not fast enough. Shout out to Pam. Pam was with us last night. She has also gifted you guys an additional 10 memberships. Look at that, guys. In less than 10 minutes, we have shared 25 memberships through Mama D, through Break of Dawn, and through Pam. Pam, thank you so much for contributing to that. And if you received a membership, guys, please say thank you. Well, I don't want to keep us from the courtroom for far too long, so I am going to bring us to the courtroom here. It looks like they're back. So why don't we skip ahead? All right, they are back. And of course, they go mute. Why? What are we doing here, guys? Where's this jury?
Your Honor, we've located some authority on main cases, United States versus Elliott 571, F2nd 880. It's a former Fifth Circuit case. Elliott dealt specifically with the question where the defendant argued that acquittal on a RICO substantive did require acquittal on a RICO conspiracy, and the court said no, it did not.
Yeah, that's not.
It's an often, it draws the distinction, but that being said, we are looking at the changes that were just forwarded to us, and think that there, for the vast majority of these, there may be a pretty simple, direct workaround that addresses the issues we've been talking about.
Okay. Well, I'm not sure we need to decide it before the jury charges anyway, so. All right. Anything else then? Otherwise, I'm going to have the jury out and go ahead and charge them. All right, let's get the jury out.
All right, guys, jury's coming out. It's getting real. Let's go. Let's see what happens. As the jury's coming out, huge shout out to Full Drinking Half Thinking with the 10. No comment, no question, pure love of the game. Thank you, Tran. Y'all check out that channel, Full Drinking Half Thinking. Gifted 5 memberships on top of that. Tran's like, let me help expand this community. I love it. Moment of truth, y'all, is coming. Shout out to Ramon with the 5. Says, don't forget, Attorney Hilton screamed at the jury that Shannon shot the gun out the car. But there's still no muzzle flash. The state is just sloppy. I agree. Shout out to Mama D with the 5. Says, grow the numbers of likes and subscribe. That's right. If you're new to me, finding me for the first time, y'all see how thoughtful we are with this content. Give me a subscribe. Help us get to 100,000. Speaking of Shannon, shout out to Shannon Soto, who gifted 5 more memberships. You guys are on a roll in the last 10 minutes giving these memberships. Thank you, Shannon Soto. If you received a membership from Shannon Soto, please say thank you to Shannon. Very, very sweet of Shannon. The state is not coordinated today. They are done with their red. They came in for blood only for their closing arguments. Like sharks. But Schardt smelled the blood in the water. Got on top of it. All right, the jury is walking in, guys. They're about to receive their jury instructions and what they need to accomplish for today, tomorrow, maybe next week. These are important words that are about to be read to them. Shout out to Chris Kringle in the chat. Santa, it's almost that time of year. You're going to be busy. Are you going to be around in December? It's almost that time of year, Chris Kringle. Did I tell you what I wanted? Did I tell you what I wanted, Santa? I got to put together my list because you should be checking it twice right now. You should be. You should be checking it twice. Nice view of the Shannon Stillwell. on the screen. Defense attorneys. All right, jury, y'all dragging today. It's an important day. Y'all notice that? No days off? That they're wearing black? Or it's just Simone wearing black. Okay, I did see this in the Law and Crimes chat. I think this is a glitch for some reason. The judge is speaking to the jury. The jury is in the box. They are seated. We cannot hear what's happening. So, court of a public opinion, we are like, what the hell? We want to watch what's being said right now, and we can't hear it. Oh, man. Okay, let me go back to Law and Crimes chat. I think this is them. Does it fix? How long does this happen? There's always something. Okay, I hear something, so maybe it fixes.
Violation of the Georgia Controlled Substances Act, 61, possession of a firearm during the commission of a felony, and 63, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Mr. Stillwell has been indicted for counts 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act. 2 and 49 are counts of murder. 50, participation in criminal street gang activity pursuant to subsection 1 of that statute. 51, participation in criminal street gang activity pursuant to subsection B of that statute. 2 counts of possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm in counts. Those are counts 52 and 64. And then count 54, which is possession of a firearm during the commission of a felony. You will have a copy of the indictment with the relevant charges with you during your deliberations. Each defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The instructions that I give you will apply to each defendant individually. So when I say the defendant or a defendant, the instruction applies equally and separately to each defendant. Further, your determination of the issues set forth in the verdict forms must be made as to each count and as to each defendant individually. A defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a reasonable doubt is a doubt of a fair-minded and impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It's a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If after considering the evidence, you believe beyond a reasonable doubt that a defendant is guilty of an offense alleged in the indictment, you would be authorized to convict the defendant of that offense. If the state fails to prove the defendant's guilt of an offense beyond a reasonable doubt, it would be your duty to acquit the defendant of that offense. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged or that merely raise a speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction of the defendant. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes the testimony of the witnesses, the exhibits admitted during the trial, and any stipulations of the attorneys, which are facts to which the attorneys have agreed. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into stipulations about certain facts, and these 4 stipulations are marked as joint exhibits. Where parties stipulate facts that is in the nature of evidence, you must take that fact or those facts as a given without the necessity of any further proof. You make all decisions based on the evidence in this case. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and to reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. There's no legal difference in the weight that you may give to either direct or circumstantial evidence. Direct evidence is that which can be seen or heard or otherwise directly sensed. It may be brought into court in the form of exhibits or the testimony of a person who asserts that he or she has actual knowledge of a fact by personally observing or otherwise witnessing that fact. It is evidence that points immediately to the issue in question. When direct evidence points by inference to an obvious, likely, or reasonable conclusion, even though that conclusion is not directly observed or otherwise sensed, that's said to be circumstantial evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that tends to prove or disprove another fact by inference, that is, with consistency with such a fact or elimination of other facts, or that only tends to establish a conclusion in question by its consistency with such conclusion or its elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence alone, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or a greater degree of certainty on the part of you, the jury, to return a verdict based on circumstantial evidence than upon direct evidence. There's no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for you, the jury, to decide. And whether it's dependent upon direct or circumstantial evidence or both, the true test is whether there's sufficient evidence, whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. You, the jury, must determine the credibility of the witnesses. In deciding credibility, you may consider all of the facts and the circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or their lack of interest in the case and the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are witnesses who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it's properly entitled to receive. In determining the credibility of a witness, you may consider, where applicable, evidence offered to attack or challenge the witness's credibility, and this may include evidence of a character for untruthfulness, bias toward a party, or felony criminal convictions. In determining the credibility of any witness whose credibility has been attacked or challenged, as I've described above, and any testimony given by him or her in court, you may consider, where it's applicable, evidence offered to support the credibility or believability of such a witness. The credibility of a witness may also be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony that the same witness gave before the trial started. It's for you to decide whether there's a reasonable explanation for any inconsistency in a witness's pretrial statements or testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. In assessing the credibility of a witness, you may consider any possible motive in testifying if that is shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of all of the witnesses. The testimony of a single witness, if believed, is generally sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. An exception to this rule is made where the witness is an accomplice. The testimony of an accomplice on its own is not sufficient to warrant a conviction. An accomplice's testimony must be supported by other evidence of some type, and that evidence must be such as would lead to the inference of the guilt of the accused, independent of the testimony of the accomplice. It's not required that supporting evidence be sufficient to warrant a conviction, or that the testimony of the accomplice be supported in every material particular. The supporting evidence must be more than that a crime was actually committed by someone. It must be sufficient to connect the accused with the criminal act, and must be more than sufficient to merely cast upon the accused a grave suspicion of guilt. Slight evidence from another source that connects the accused with the commission of the alleged crime and tends to show participation in it may be sufficient supporting evidence of the testimony of an accomplice. In order to convict, that evidence, when considered with all of the other evidence in the case, must be sufficient to satisfy you beyond a reasonable doubt that the accused is guilty. The testimony of one accomplice may be supported by the testimony of another accomplice. Whether or not the testimony of one accomplice does in fact support the testimony of another accomplice is a matter for you to decide. The sufficiency of supporting evidence of an accomplice is a matter solely for you to determine. Whether or not any witness in this case was an accomplice is also a question for you to determine from the evidence in this case. Any out-of-court statements made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider the statement only against the particular defendant who made it. A defendant in a criminal case may take
Pause. This trial is brought to you by Diet Coke. Let's continue.
the stand and testify and be examined and cross-examined as any other witness. However, a defendant does not have to present any evidence nor testify. If a defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose or against some parties and not others, or for some counts and not others. I have previously instructed you as to how to consider particular evidence that was limited over the course of this trial. Such evidence may be considered by you only for the sole issue or purpose, or against only the party, or only for the counts for which that evidence was limited, and not for any other purpose or against any other defendant or for any other counts. You have received evidence of certain prior convictions of these defendants as well as certain other witnesses in this case. You may consider the conviction of Mr. Kendrick only against Mr. Kendrick and only as to count 1 and as to the required element of being a convicted felon in count 63. You may consider the convictions of Mr. Stillwell only against Mr. Stillwell and only as to count 1 and as to the required element of being a convicted felon in counts 52 and 64. You may consider the convictions of any witnesses only insofar as they may relate to attacking the credibility of that witness and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. In addition, some but not all of the factors you may consider in assessing the reliability of any identification are the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident, the possibility of mistaken identity, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have had, whether the witness on any prior occasion did not identify that person as the alleged perpetrator, and the length of time between the crime and the out-of-court or any out-of-court identification. It's for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify someone beyond a reasonable doubt as the alleged perpetrator or a party to an act. It is not necessary that the defendant show that another person committed the alleged act. The burden of proof never shifts to the defense. Defendants are charged with crimes against the laws of this state. A crime occurs when a law is violated by a defendant's intentional action. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe it existed from the facts proven before you. It may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a criminal statute, but it simply means the intention to commit the act that is prohibited by a statute. A defendant will not be presumed to have acted with criminal intent, but you may find such an intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. Whether or not you make any inference or inferences such as that is a matter solely within your discretion as the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person directly commits the crime, intentionally helps in the commission of the crime, or intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though the person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crime of murder, that's counts 2 and 49, possession of marijuana with intent to distribute, count 58, or possession of a firearm, counts 52, 54, 61, 63, and 64, was being committed, and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt in order for you to convict on those counts. If you find from the evidence in this case that the defendant had no knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts that I just referenced was being committed, or that the defendant did not knowingly and intentionally commit, participate in, or help in the commission of the alleged offense, then it would be your duty to acquit the defendant of that count. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of murder, possession of marijuana with intent to distribute, or possession of a firearm in the counts I just mentioned was being committed, and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant of that count. You are not authorized to find a person who is merely present at the scene of the commission of a crime at the time it was committed guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in its actual perpetration of the crime, or participated in the criminal endeavor. You are not authorized to fine a person who is merely
Now, this trial is being sponsored by Sparkling Water.
associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of a crime, unless the evidence shows beyond a reasonable doubt that the person helped in the actual perpetration of the crime or participated in the criminal endeavor. Next, I'm going to define for you the elements of the crimes that are alleged as counts against either defendant. Then I will define the meaning of any crimes that are alleged as an overt act, but that I have not yet defined. When a count of an indictment charges that a defendant committed a crime in more than one way, the state does not need to prove that the defendant committed the crime in every one of the ways alleged. The state may prove that the defendant committed the crime in any one of the ways charged. If the evidence shows that the crime was committed by the defendant in any one of the ways charged, you would be authorized to convict him of that count. And RICO is one of the counts that is charged as having been committed in more than one way. In order to convict, the state must prove that the crime was committed by the defendant in at least one of the ways charged. For conspiracy to violate subsection A of the Racketeer, Influence, and Corrupt Organizations Act, which I'm going to refer to from now on as the RICO Act, the state must prove that the defendant knowingly and willfully conspired with one or more others, co-conspirators, to acquire or keep money or other personal property through a pattern of racketeering activity, and that any of the co-conspirators committed an overt act after May 10th of 2017 to further a criminal objective of the conspiracy. For a conspiracy to violate subsection B of the RICO Act, the state must prove that defendant, while associated with an enterprise, knowingly and willfully conspired with one or more others to participate in the enterprise through a pattern of racketeering activity, and that any of the conspirators committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. Conspiracy means an agreement between at least two people to commit an unlawful act. The agreement may be express, that is, stated or written, or it may be tacit, that is, a mutual but unspoken understanding to accomplish or to pursue a common criminal objective. The existence of a conspiracy may be inferred from the nature of any acts done, the relationships, interests, or conduct of the alleged conspirators before and after any alleged offense, and other circumstances which may disclose a common criminal design. However, mere association with an enterprise is insufficient by itself to establish a conspiracy to violate the RICO Act. The state does not need to prove that each conspirator agreed with every other conspirator, knew all of his fellow conspirators, was aware of all of the details of the conspiracy, or contemplated participating in the same interrelated crimes as every other conspirator. Whether a conspiracy existed is a matter for you to determine. Overt act means an outward act made in furtherance of a conspiracy. The overt act may, but does not have to be, a crime in and of itself. Some of the overt acts alleged in this indictment, if proven, would be crimes. You can tell which those are when you have the indictment back with you, because they will list a cite to a criminal code section. Later in these instructions, I will define for you any alleged crimes that are alleged in the overt acts that I have not already defined when I'm defining the substantive counts. Enterprise means a group of individuals who are associated in fact, whether or not all of the members know each other. To be an enterprise under the RICO Act, the group must have a common purpose and ongoing nature sufficient to pursue its purpose or purposes, and at least a loose or informal relationship amongst those involved. The group does not need any form or structure beyond what is necessary to conduct a pattern of racketeering activity. The group may be associated together for both legal and illegal purposes. In determining whether an enterprise existed, you may consider any evidence of a pattern of racketeering activity. When people conspire together in an unlawful enterprise, any act done by any of the conspirators to further the unlawful enterprise is considered to be an act of all of the conspirators. However, each conspirator is responsible for the acts of other conspirators only to the extent that those acts are naturally or necessarily done to further the unlawful enterprise. If you find that the defendant did not knowingly and willfully join a conspiracy as described above, then you cannot contribute the statements or acts of another person to the defendant. Racketeering activity means committing or attempting to commit any of these crimes: murder, attempted murder, aggravated assault, aggravated battery, theft by receiving stolen property, armed robbery, terroristic threats, use of an item with an altered identification mark, possession of a firearm during the commission of a felony, possession of a machine gun, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, possession of a weapon by an inmate, possession of a cell phone by an inmate, possession of codeine with intent to distribute, possession of hydrocodone with intent to distribute, possession of marijuana with intent to distribute, possession of MDMA with intent to distribute, possession of methamphetamine with intent to distribute, possession of cocaine, or possession of oxycodone. I will define these crimes for you shortly. Racketeering activity also means any act or threat that involves murder, robbery, theft by receiving stolen property, or dealing in narcotic or dangerous drugs. A pattern of racketeering activity means engaging in at least 2 acts of racketeering activity within 4 years of each other in furtherance of one or more interrelated incidents, schemes, or transactions. Interrelated here means acts that have the same or similar intents, results, accomplices, victims, or methods of commission, or that are otherwise interrelated by distinguishing characteristics and that are not isolated incidents. The criminal objectives of the conspiracy alleged here are preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence, obtaining money, weapons, or other property through acts of racketeering activity, including robbery, theft, and the unlawful sale and distribution of drugs, and obstructing law enforcement investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. A person commits the offense of violation of the Georgia Street Gang Terrorism Prevention Act, which I'm going to refer to from now on as the Gang Act, when that person, while associated with a criminal street gang, commits a crime that constitutes criminal gang activity. To prove a violation of subsection A of the Gang Act, as alleged in counts 50 and 57, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity, and a nexus, that is a connection between the crime committed and the gang, i.e. that the crime was committed to further the interests of the gang. To prove a violation of subsection B of the Gang Act, as alleged in count 51, the state must show the existence of a criminal street gang, that the defendant is associated with that criminal street gang, that the defendant committed or participated in criminal gang activity in order to maintain or increase his status or position in the gang, and again, a nexus or a connection between the crime charge and the gang. That is, that the crime was committed to further the interests of the gang. Criminal street gang means any group of 3 or more persons associated together which engages in criminal gang activity. The existence of criminal street gang may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or attire, or other distinguishing characteristics, including but not limited to common activities, customs, or behaviors. Criminal gang activity means the commission, attempted commission, conspiracy to commit any criminal offense that involves violence, possession of marijuana with intent to distribute, possession of a weapon, or use of a weapon. For purposes of count 50, 51, and 57, which are the gang counts, murder, possession of marijuana with intent to distribute, and possession of a firearm during the commission of a felony constitute criminal gang activity.
Brought to you by
For
Diet
malice
Coke.
murder, the state must prove that a defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice where there does not appear to be significant provocation, and all of the circumstances of the killing show an abandoned and malignant heart. The state does not have to show premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state may, but does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For possession of a firearm during the commission of a felony, the state must prove that a defendant had a firearm.
So I know that this is really dry, guys, but what she's actually doing is in the jury instructions, she's also she's giving them definitions of what the law means and how to apply it. So that's why it's taking so long. She's going through all of the concepts that they have to look at. It's a super important part of the trial. So that's why it's taken so long. But they need this because they're going to be referring to these jury instructions as a guide as they start their deliberation process. So as you can see, it's a lot of information here, but let's keep going.
Firearm on his person or within arm's reach of his person while committing a felony, which is one of the following: a crime against or involving another person, or a crime involving possession of marijuana with intent to distribute. Murder and possession of marijuana with intent to distribute are felonies, and for purposes of this offense, a firearm includes any handgun. The indictment charges each defendant with possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. I am not going to charge you on that crime because the state concedes that the description of the crime in the relevant counts of the indictment left out an element of either the defendant having previously been convicted of a felony, or of the defendant having previously been convicted of a felony involving the use or of possession of a firearm. That should be or. So you will be considering only the lesser included offense of possession of a firearm by a convicted felon when you get to those counts. And for possession of a firearm by a convicted felon, the state must prove that the defendant possessed a firearm after having been convicted of a felony. Possession of a firearm during the commission of a felony and possession of a firearm by a convicted felon are both felonies. And again, for purposes of this offense as well, a firearm includes any handgun. For possession with intent to distribute marijuana, the state must prove that the defendant possessed any amount of marijuana with intent to distribute. Intent to distribute means intent to unlawfully deliver or sell. Marijuana means all parts of the plant of the genus cannabis, whether growing or not, the seeds, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of such plant, its seeds, or its resin. Marijuana does not include the completely defoliated mature stalks of such plant, fiber produced from such stalks, oil or cake, or the completely sterilized samples of seeds of the plant which are incapable of germination. And it does not include hemp or hemp products, and it does not include samples of tetrahydrocannabinols, or THC. The state must prove that the defendant possessed the marijuana and/or the firearm at issue in this case. Possession may be either actual or constructive. It also may be either sole or joint. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the marijuana or over the firearm, depending upon which count you're considering. Constructive possession means that at the time of the alleged offense, the defendant did not have direct physical control over the marijuana or the firearm, but did knowingly have both the ability and the intention to exercise control over the marijuana or the firearm. Sole possession means that only the defendant had possession of the marijuana or the firearm. Joint possession means that the defendant shared possession of the marijuana or the firearm with at least one other person. If you find that someone other than the defendant had an equal opportunity to possess the marijuana or the firearm, you would be authorized to convict the defendant only if the state proves that the defendant knowingly possessed the marijuana or the firearm. And I'm now going to define for you any alleged crimes that are alleged in the overt acts that I have not already defined in the substantive counts. So the following definitions apply only to certain acts that are alleged in count 1 of the indictment as overt acts. Aggravated assault with a deadly weapon. For aggravated assault, the state must prove that the alleged perpetrator assaulted another person with a deadly weapon. Assault means to commit or to attempt to commit a violent injury on the person of another. And to prove assault, the state doesn't have to prove the other person was actually injured. However, the state must prove that the alleged perpetrator attempted to cause a violent injury to the person. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. Aggravated battery. For this crime, the state must prove that, for aggravated battery, the state must prove that the alleged perpetrator maliciously caused bodily harm to another person by seriously disfiguring a part of the body. In deciding whether or not an alleged perpetrator acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the resulting bodily harm without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the particular bodily harm may result. For armed robbery, the state must prove that the alleged perpetrator took another person's property from the immediate presence of the other person by using an offensive weapon and with the intent to commit theft. An offensive weapon is an object that's either likely to cause or actually does cause death or serious bodily injury if it's used against someone. Conspiracy to commit murder. A person commits conspiracy to commit murder when that person conspires with one or more others to commit the crime of murder. Murder has been previously defined. Criminal attempt. A person commits criminal attempt to commit a crime when, with the intent to commit that crime, the person performs any act that constitutes a substantial step towards the commission of the crime. Criminal gang activity has been previously defined. Criminal use, a person of an article with an altered identification mark. A person commits the offense of criminal use of an article with an altered identification mark when he possesses a firearm from which he knows that the manufacturer's serial number or any other.
As we are listening to all of these definitions real quick, wanted to take a moment because I haven't seen this person in a very long time. Huge shout out to Viva Wood Life, who is now your stream sponsor. He hits me with $100 super chat. Thank you so much, Viva. He says, for the love, #trust Unc. Unc, it's good to see you. I miss seeing your name, so it's good to see you on my side. I appreciate you. If y'all could do me a favor and type Viva in the chat, that would be fantastic. So what are we watching, guys? We're watching the jury being read their jury instructions. I have to cut out at 12:30, so we will resume after I have a quick meeting, and then we will come back and continue watching it. But real quick, I wanted to interrupt and thank Viva for this super generous super chat. He supported me in many ways throughout these last 2 years on this content creator journey. So Viva, thank you so much. In the spirit of Thanksgiving, I appreciate you, Unc. Thank you so much, and it's great to see you pass through here today. Let's keep going, guys.
Other distinguishing number or identification mark has been removed for the purpose of concealing or destroying the identity of that article. Possession of a firearm by a convicted felon has been previously defined, but in addition, with regard to that offense, possession of MDMA with intent to distribute, possession of cocaine, and robbery are felonies. Possession of a firearm by a first offender probationer. For possession of a firearm by a first offender probationer, the state must prove that the alleged perpetrator possessed a firearm while on probation for a felony as a first offender. Robbery and criminal damage to property are felonies. Possession of a firearm during the commission of a felony has been previously defined, but in addition, for these overt acts, possession of codeine with intent to distribute and possession of cocaine are felonies. Possession of a machine gun. The state must prove that the alleged perpetrator possessed a machine gun during the commission of any of the following offenses: participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine. A machine gun means any weapon which shoots or is designed to shoot automatically more than 6 shots without manual reloading by a single function of the trigger. Possession of controlled substances. For possession of cocaine or oxycodone, the state must prove that the alleged perpetrator possessed any amount of cocaine or oxycodone, both of which are controlled substances. Possession with intent to distribute. For possession with intent to distribute codeine, hydrocodone, marijuana, MDMA, or methamphetamine, the state must prove that the alleged perpetrator possessed any amount of marijuana or any amount of codeine, hydrocodone, MDMA, or methamphetamine, which are controlled substances, with intent to distribute. And intent to distribute means intent to unlawfully deliver or sell. Sale of marijuana. For sale of marijuana, the state must prove that the alleged perpetrator sold any amount of marijuana, and sell here means to transfer marijuana in exchange for money or anything else of value. Possession of a weapon by an inmate. For possession of a weapon by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized weapon. For possession of a telecommunication device by an inmate, the state must prove that the alleged perpetrator, while an inmate, possessed an unauthorized cell phone. Conspiracy to possess a telecommunication device by an inmate. A person commits conspiracy to possess an unauthorized telecommunication device by an inmate when that person conspires with one or more others to commit the crime of possession of a telecommunication device by an inmate. For terroristic threats, the state must prove that the alleged perpetrator threatened to commit a crime of violence and that the threat was made. Theft by receiving stolen property. A person commits theft by receiving stolen property when that person receives or keeps stolen property and the person knows or should have known was stolen, unless the property was kept or received with the intent to restore it to the owner. knowledge on the part of the alleged perpetrator that the property was stolen, or evidence sufficient to show beyond a reasonable doubt that the alleged perpetrator had reason to know the property was stolen, is an essential element of this offense. Knowledge that the property was stolen may be shown by circumstances that would excite suspicion in the mind of an ordinary person. The burden is on the state to prove beyond a reasonable doubt that the alleged perpetrator had knowledge, or under all the circumstances should have had knowledge, that the property in question was stolen and was in the alleged perpetrator's possession. All right, that's it for the overt act crimes. All right, the law provides that criminal action shall be indicted and tried in the county in which the crime was committed. In a prosecution in any case in which it can't be determined that what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt it might have been committed. We don't have that here, do we? So essentially just the state must prove that the criminal actions alleged as counts in this case, that they have to be tried and indicted and tried in the county in which the crime was committed. So venue, that is that the crime was committed in a particular county, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue may be proven by direct or circumstantial evidence or both. To prove venue for the RICO count, the crime is considered to have been committed in any county in which an incident of racketeering occurred, or in which an interest or control of an enterprise or personal property was acquired or maintained. The defendants are each charged with certain offenses that are set forth in various counts of the indictment. Each count is a separate and distinct offense, and you must independently evaluate the evidence against each defendant and as to each offense. The fact that you reach a conclusion with respect to one offense or with respect to one defendant does not necessarily mean that the same conclusion will apply to any other charged offense or to another defendant. Each count of the indictment before you is separate and distinct. You must evaluate evidence as to one count independently from evidence of each other count. You must evaluate the evidence as to each defendant independently, and you must render a verdict as to each count and as to each defendant individually. If, after considering the testimony and the evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, committed an offense as alleged in the indictment, you would be authorized to find the defendant guilty of that offense. In that event, the form of your verdict for that offense would be to find the defendant guilty. If you do not believe the defendant is guilty of an offense as alleged in the indictment, or if you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense. In that event, the form of your verdict for that offense would be to find the defendant not guilty. You are to make a separate determination of guilty or not guilty as to each offense and as to each defendant. Your verdict as to each count must be unanimous. That means that you must be unanimous in your determination that the state has proven every element of that count as defined and listed above beyond a reasonable doubt. And you'll have a copy of these instructions out with you so that you can see what each of the elements of each of the offenses is. Again, the elements are listed above where the crimes are defined, and you must be unanimous that each element has been proven. Let me explain what that means for a few of the elements for count one a bit more specifically. And that's the conspiracy to violate the RICO Act. You must be unanimous as to the pattern of racketeering activity that the defendant agreed would be committed. But because count one is charged as a conspiracy to violate the RICO Act, it's not required that the state prove that any conspirator actually committed an act of racketeering activity. And on the overt act element, you must be unanimous that a conspirator committed an overt act after May 10th, 2017 to further a criminal objective of the conspiracy. And you would note on your verdict form that and any other overt act committed in furtherance of the criminal conspiracy to which all 12 of you unanimously agree. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of this case, upon the credibility of witnesses, upon the evidence, or upon the guilt or innocence of either defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status for or against any party. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Don't hesitate to change an opinion if you are convinced that it's wrong. However, you should never give up an honest opinion simply to be congenial or to reach a verdict solely because of the opinion of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. And these rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as the foreperson, dated and returned to be published in open court. During your deliberations, any communications from you to the court must be in writing, signed and dated by the foreperson, and given to a bailiff. And let me add that given that the evidence is closed, my ability to respond to questions may be limited. Evidence that was admitted by audio or video recording can only be played here in the courtroom, so any request to review or listen to that evidence again must be made in writing by you to the court, and then it'll be replayed in the courtroom. And that is the end of my instructions. I'm going to excuse you all to the jury room now to elect your foreperson. Don't begin deliberations until you have the indictment, the evidence, and the verdict forms and some copies of this charge out with you. And I'm going to ask jurors number 387, 409, 449, and 508 to hang back with me. And the rest of you can return to the jury room to elect your foreperson.
All rise, ladies and gentlemen.
It's love there in all black. It's now we wait, guys. Going to be an interesting afternoon, most likely more eventful day tomorrow. What do y'all think? How long is it going to take them?
All right, y'all are the alternates in the case. Considering the length of this trial, it was critical that we had alternate jurors in case we lost any jurors. And as I think y'all know, we in fact started with 2 more of you and lost 2 along the way. I don't know how long deliberations are going to take. And so it's possible that even now we may end up losing a juror or more. So y'all are still on jury duty. You're not going to be deliberating right now, but you continue to be under all of the instructions that have been applicable to you for the entirety of this trial. You cannot discuss this case with anyone. You cannot allow anybody to discuss the case with you. You cannot go now and look up any articles about this case or anybody involved in it. You can't look at any kind of social media or any other kind of accounts of this trial or anybody involved in the trial. Essentially, you're still on jury duty. I am going to, for the next hour or so, keep y'all around here. And Sergeant, maybe, I don't know, I'm sure there's probably another jury room that they can retire to. While y'all are on jury duty and the jury is deliberating, I want y'all to stay within an hour or so of this courthouse. If we're ever on a break, we've got Thanksgiving break coming up. Obviously, y'all can go and do whatever your Thanksgiving break plans were because the jury's not going to be in session, court's not going to be in session, we're not going to be deliberating. But even when you're on those breaks and any others that might occur during the deliberation process, you still can't talk to anybody about the case or allow anybody else to talk to you about the case or look for any information in any way about the case. So essentially you remain on the same instructions, just when we're on break, you're on break too. When the jury is deliberating, I need y'all to be where, if we need you, we can get you within an hour, down here within an hour or so, okay? So for right now, y'all can go and grab your things. You can say goodbye, it's been great. I may see you again to your fellow jurors, and then we'll have you in one of the other jury rooms for a little while at least. And if I'm gonna release y'all for the day, I'll let y'all know that. But again, just kind of stay within an hour or so of the courtroom. And just like you've sort of kept your cell phones in a way that we can communicate with you, continue to do that in case we need to. Thank you very much.
Right, instructions to alternates, done.
Are there objections to the chart?
Just a few things that you mentioned, Your Honor.
Okay,
Page 2, Your Honor.
on page 2? Okay,
When reading participation in criminal street gang activity for count 50, you said subsection 1 and not A. So I just wanted to
hang
make
on a second, let me get there. Page, where are you talking about?
So count 50, where it has participating in criminal street gang,
Yes.
you said section 1 and not A.
Okay, do you want me to call them all back in and say I meant to say A, or they'll have copies of this out there? And it'll be on the verdict form correctly?
Yes, Your Honor.
All right.
That's fine. I didn't know if I had something different than what you had, and so I wanted to make sure that what I have in front of me was correct.
Okay,
Only as to page number 9, when you, last paragraph, any out-of-court statement,
hang on. Yes,
as we were reading it, the thought came that maybe we should add any out-of-court statement made to law enforcement, made to the police, made by one of the defendants on trial in this case after the alleged criminal act.
we probably should have.
So just,
I gave y'all this, I don't know how many different times to look at and ask you. I don't know how many different times for any kind of comments or corrections. So what do you want me to do?
can we add it, and then when you send it back,
Sure.
that's all, Your Honor. I'm just going back.
Made by one of the defendants, made to law enforcement by one of the defendants on trial?
Yes, Your Honor.
Okay, we can do that.
And as of right now, those are the only ones that I see.
All right, appreciate it. Thank you. Anybody else?
I have no objections to your reading of the jury charges, Your Honor. I just need to renew my request and objection to exclusion of jury charge 3.01.10, which is the justification, as I requested justification for my client's possession of firearm by a convicted felon. I requested that charge, so I'm just renewing my objection to the exclusion of that charge, as well as the separate and distinct charge that overt acts need to be proved. An overt act needs to be agreed upon unanimously by all the jurors. I know, Your Honor, stance that you referenced the need for unanimity, being unanimous. I always struggle with that word.
Okay,
Within the jury charges, and I understand that, but I'm just going to renew my objection.
okay.
Thank you.
All right. Then we will, y'all have agreed as to what evidence goes out?
Yes, Your Honor, there is we're including a flash drive with a list of the exhibits, the Stillwell exhibits.
Okay.
And I thought it would be appropriate, and if it's not appropriate, please object. It's just a list of the exhibit numbers, because the flash drive is little, so we can't list them all. So we're printing on a piece of paper.
Okay.
And we're just going to attach the flash drive to the piece of paper.
Okay. And those don't go out. You're just saying you're listing them.
My understanding, well, they can't play them. My
Right.
understanding is that all the media was going to go in the back room. They can't play it, but then they could ask if they wanted us.
Just so they'll have a list of what it is?
I'm not even proposing the list of what it is, as in what each exhibit is, but just that these are the exhibits that are on this flash drive. I'm not suggesting,
We don't normally send the actual media out with them.
Okay,
I mean,
we
they
had
can,
this-
it's certainly in evidence and they certainly can consider it. They just would need to say, hey, I'd like to watch the FedEx tape again.
Okay, my understanding, and I had spoken to some members of the state about this. The understanding I had was that the media was going to go out, but of course they have no way to play it, but then they could request.
Okay, are they gonna even, if it all, for instance, goes out in a bin, are they gonna even know what it is? Like, are they all labeled? Yes? I mean, it's fine with me if that's the way y'all wanna do it.
The only other thing we were going to ask to do, I believe the defense counsel has an objection, we were going to send a legend out with the letters and what letter is associated with what act, so that they would know. We
What
organized
letters? I
them.
don't know what you mean by that.
So every act that we presented, so for example, VV was the Shamel Drinks homicide, so that they could know when they pick up a letter, what that was in reference to.
I'm going to object to that. The state's kind of direction of compartmentalizing the evidence, and quite honestly, some of the evidence that was admitted under certain letters applies to certain other cases. I mean, these aren't distinct. I know that they're charged as distinct overt acts, but Walter Murphy testifies, for
Right.
instance, and he has things they admitted to Walter Murphy might have a WW, just for instance, but what he testified to involved different acts.
I mean, I think that as they were listening to the evidence, they could write down the number of the exhibit. So if they want to flip through their notes and say, you know what, I was really interested in 53 WW, then they can find that, or if it's media, they can ask to re-listen or replay it. I don't think that it's really appropriate to say, here's kind of the state schematic of the evidence. Okay. So have y'all otherwise agreed on what evidence goes out with them and what evidence doesn't?
So I've been presented some case law this morning, and we've discussed it. I don't have any problem with the GBI reports going back. I know that was one bone of contention. I don't have any problem with the ME reports going back. We've been going back and forth about two issues: the CAD reports and the demonstratives. I'm objecting to both the CAD reports and the demonstratives going back.
Okay. You wanna?
I join in.
Okay. All right. Does the state feel that the CAD reports or the demonstratives should go out?
Yes, Your Honor, we have case law regarding demonstrative evidence.
Okay.
That demonstrative evidence does go.
All right, guys, it's just about 12:24 Eastern Standard Time. The jury is about to get ready to deliberate. They are selecting their four-person right now, and what you're seeing happen on the screen right now is Simone and the defense attorneys determine what evidence is going to go back into the deliberation room with the jury members. So I hate to do this to y'all, but listen, I do have a 12:30 and I do need to run, but it looks like they're about to wrap up. So here's the deal. I'm around for the rest of the day. So as soon as the verdict comes in, we're going to start up another stream, because otherwise we're going to be sitting here waiting for them. So we could either get a decision today, I don't know, it could be tomorrow, but I'm on standby to be here to report it live with you guys as soon as it comes in. All right, so listen, stay on standby. Stay tuned into this channel, all right? But I'm going to take off for now, and we will continue as soon as the jury comes back with a decision. And hey, I mean, it could be Juror 56. All you guys think it's going to be Juror 56, right? Anywho, stay tuned. It's going to be a busy day, and it could be tomorrow as well. And in the meantime, if you have any questions, bring them to our next stream, and we will do that. All right, y'all. I'm going to take off. Stay safe out there. See you in the next one. Bye.